Back. Our goal today is we're finishing up client confidences, and then we're going to move into attorney-client privilege, which won't take that long. You did the silk procedure. And then we're going to start in our next class talking about the lawyer-client relationship. You realize that from these 5 chapters, we will have established the components of an attorney-client relationship. And now, after chapter 5, we're going to be looking at things that can disrupt that relationship, conflicts. And so those 4 or 5 chapters on conflicts will resonate with you because of all of the things that we've done with the attorney-client and the attorney's role. So we started off this course even talking about the wide variety of roles that an attorney has: advisor, counselor, officer of the court, all of these things. And so to navigate all of these complex things, we have to know how these rules function. And we focused on Rule 1.6 because it tells us that we shall not reveal information related to the representation. Very broad category. That's not just what we learn from the client, but anything that we learn that could be confidential. So we have to preserve those secrets, 1.6, or anything that we find out. But then we looked at some exceptions, and we know that those exceptions are permissive, the lawyer may. And if you look at the chart on page 116 and 117 in your text, that's what we had in terms of 1.6. And then we started developing how we preserve confidences. We looked at a case called rat poison on page 133. And we were really concerned about assisting this ongoing crime, perhaps, and our duty to disclose what the client had told us. So we had a number of different options. We talked about contact the prosecutor, avoid new charges, plea bargain, go to the client's home and seize the records. We said that's probably not a good idea because we get involved in things that could be detrimental to our professional viability, particularly obstruction of justice. Don't worry about the rat poison in other homes. Just represent Harry. Go with Harry and collect the rat poison, remove the harm, or withdraw from the representation. That's probably harsh. But if you look at something like comment 3 to Rule 4.1, it says ordinarily a lawyer can avoid assisting a client for crime or fraud by withdrawing from the representation. And we said that's probably a little bit too drastic in this particular case. A number of you said you would just keep working with your client, trying to get him to remove the rat poison and the like. And we finally noted that in the real case, the prosecutor finally obtained a search warrant, seized Harry's records. Harry cooperated with the authorities. A government agency came in and visited the homes and removed the poison before any children were exposed. So Harry's lawyer then worked out a plea bargain, and Harry was charged with a single count of manslaughter. That was rat poison on 135. Oh, I'm sorry, on 133. Then on 135 draws this parallel, 1.6b2 and 1.6b3. Now that is in the book to show you that both of those sections of the permissive revelation under 1.6 are triggered and they have the same language in them. I want to emphasize this. It says, in furtherance of which the client has used or is using the lawyer's services. Both in 1.6b2 and b3, it says that the lawyer may disclose if the lawyer's services have been used. And so 1.6b2 talks about stopping any future conduct. 1.6b3 talks about, I would say, future, present, and past conduct, because you have to prevent something that could occur, mitigate, or rectify. And so for both of these, the key is have this language. in that language is in furtherance of which the client has used or is using the lawyer's service. And that's going to bring us to Reese's Leases. Sorry about the hokey name. And you're going to be really surprised at the outcome of this case. It's an actual case. So we know that we have this mandatory duty not to disclose. It may be permissive under 1.6, and we went through all of those. And we're really looking at the lawyer's duty to prevent his or her services from being used in criminal or fraudulent conduct. Can prevent it, can mitigate it. This is all on page 135. So notice, we want the client to come to us and talk about things that have happened in the past. If you look at the bottom of page 135, if the crime or fraudulent conduct is passed, the client did not use the lawyer's services to assist in that conduct. If the client is hiring the lawyer for representation, that's fine. The lawyer may not reveal that information under 1.6b3. Nothing future is happening, nothing present is happening, and there is no ongoing connection to something that happened in the past. So you see at the top of page 136, you have those two examples. The first example, you cannot reveal, and the second example, you may reveal. So the rule is this: a lawyer is allowed to reveal information about crimes and frauds only if the lawyer's services were used in the perpetration of the crime or fraudulent act. We don't want lawyers to turn on their client and tell everything that the client did. And we know that this is permissive. So that helps us set up Reese's Leases on page 145, which is where we left off. Now what about this case? And the big home run question is revelation permissive here? In other words, can the lawyer make a decision not to reveal and everything will be okay? So this is an actual case. It happened in New York. It was called Other People's Money, was the case, OPM. And we set up the facts to look. This law firm, this is a bad sign too. This is going to show a conflict. We haven't done conflicts yet. But notice this. The law firm depends upon its existence on 60% of the business that this client brings in. That's bad. So that's going to color some judgment as well. And we're concerned about these fraudulent bank leases that we learned about. And we ask the question, why does the bank keep lending to a company that is losing money? And we find out that we have counterfeit leases for fictitious transactions on leased cars. In the real case, it was computers, but it's the same thing. And then we have these phony leases making the business look a lot bigger than it actually is. And then we have our client telling us all of this stuff. How they modify the leases, how they forge the leases, how they create new leases to generate more income. And then on the top of page 147, you have the real problem, fully presented. Now notice the lawyer is told, this is paying your mortgage as well as mine. Of course you know I'm telling you this in the strictest confidence. So attorney wrote opinion letters attesting to the validity of these leases. These go out to third-party banks. The banks rely upon your expertise. Your client says, no, you didn't do anything fraudulent. You're just attesting to what we have, literally, and that's what we have. That's what you represented. You're home free. So we're dealing with this language in furtherance of which the client has used the lawyer's services. We admonish our client, this is risky behavior. We're all going to go to jail. It's got to stop. And our client says, okay, I get it. I know it's bad. We're just going to stop anyway. I was beginning to get worried. We won't fiddle with any more leases, I promise. We think for a moment, and the attorney tells the client to stop. I guess that might be the best we can do for now. So what do we do in this situation? What would you do in this situation? And so what's going to sort of turn how you deal with this is, how do you characterize this conduct? You're going to be amazed at this case. There's a judge involved in this case that was giving advice. A professional responsibility professor was giving advice in this case. And on some level, they got it wrong. Maybe it's easy for us to say in the classroom what we would do, but it's amazing. You'll see, seems like everybody got it wrong. Or maybe they wanted to get it wrong because so much money was involved. So how would you resolve this? What would you do? And notice on page 147 we have options. Reveal the fraud to the bank or the district attorney if Reese refuses to do so. So, reveal. I guess we'd be doing that to mitigate or rectify damage that's already been done, and we can't really determine if it's still ongoing, but we decide that perhaps this needs to be dealt with. If you look at comment 8 to Rule 1.6b3, it says, addresses the situation in which the lawyer does not learn of the client's crime or fraud until after it has been consummated. That's clearly our case. Look, this is paying your mortgage. You signed off on this. Now you know, what do you do? Although the client no longer has the option of preventing disclosure by refraining from the wrongful conduct, there will be situations in which the loss suffered by the affected person can be prevented, rectified, or mitigated. In such situations, the lawyer may disclose, permissive. So would you disclose? That's one option. Another option is, this is a lot of money. I'll resolve any doubt in favor of my client. I have undivided loyalty to my client. The client told me they're not going to do it anymore. I believe them. Let's just move on. So do not reveal the fraud and just keep representing. Or do not reveal the fraud but say, well, I can't represent you anymore. I don't feel comfortable with that. So what would you do? Reveal. Stop representing. I don't want to be associated with you. I'm just going to leave it alone. Or say, well, if we're very careful moving forward, I accept your contriteness about this unlawful conduct. We can move on together. That was in the past. We're starting a new relationship now. We're moving forward. What would you do? Mr. Mattingly, would you stay in it or what? What do you think?
My initial...
I saw you looking like, oh, like, man, this is a lot of money, though. A lot of money. A lot of money.
And I think
this is about $70 million when we add up everything towards the end. You'll see. A lot of money. So go ahead.
so. My initial instinct, I think, would be to want to trust them. They're not going to do that anymore and move forward. But at the same time,
Okay, tell me about that, because we talk about assessment of the risk, and what would make you sort of say, well, okay, I believe you and we can move forward? Because this is some bad stuff, and you might be connected to it too, because remember, this is what we're looking at. In furtherance of risk the client has used or is using the lawyer's services. So we could be on the hook for some liability too. So what would make you want to take the risk of trusting the client? Not a wrong answer or anything, I'm just asking. Why would you trust your client?
Just the relationship, the ongoing business relationship, as well as the ongoing attorney-client relationship, and just the loyalty to the client, I guess. But if they didn't stop doing that, then I mean, you could be on the hook for like conspiracy or something.
Yeah?
So, even though my initial instinct is to, move forward and let it slide, I don't know, I think it would probably be best to maybe end that relationship.
Okay. So what's wrong with saying something like this? This is all permissive. 1.6 says may reveal. And there is something in the rule that says if you choose not to reveal when you have the option of doing so, you can't be held liable because you're simply exercising your discretion as an attorney. Is that this situation or is this something more? So what about assessing continued representation and what that means to outside parties, like the banks? You have any concern about continuing this representation if we're talking about the banks? Yes, go ahead.
I feel like 4.1b might apply.
Okay, now tell me about that.
Because that one basically says you have to disclose to a third person if the disclosure is necessary to avoid assisting a criminal or fraudulent act by your client.
Oh, that's right.
So,
now, go ahead.
I mean, I feel like if they've already borrowed the money, it's going to have to be paid back, and they're probably not going to be able to pay it back without continuing to do this.
That's good. Now, well, don't we have a problem? And this is what we're talking about. This is what is confusing about this rule. And remember I pointed out on page, where was it at? Yeah, on page 143. Even the book says, obviously this is confusing. We have this discretionary language 1.6 that says may permissive. We know we cannot engage in fraud. We know that we may disclose if we know that our services have been used in furtherance of a crime or fraud. We know that we have to be honest in transactions with others. But we have this troublesome language. Mandatory says, in the course of representing the client, a lawyer shall not knowingly, and then we go down to letter B, fail to disclose a material fact to a third person. I guess that these loans are shady. And then Mr. Johnson says, when disclosure is necessary to avoid assisting a criminal or fraudulent act by the client. That's good. But then what about this? Remember that language? Unless disclosure is prohibited by Rule 1.6. So it's mandatory but discretionary. How do you resolve that, Mr. Johnson?
So 1.6. I mean, 1.6 is like permissive, so it's not.
So I guess I'm saying, does this sort of let you off the hook? It sounds mandatory, but then it says unless disclosure is prohibited by Rule 1.6. And then can a lawyer say, well, this is permissive, this is something that's confidential, I have convinced myself that all of this happened in the past, so disclosure is indeed prohibited by 1.6 because I have the duty to preserve these confidence. See how hard I have to work to get to that? And so, I guess that's the question. What about that? In this situation, can you say there's no duty to disclose? Yes.
I don't think so, because first off, I don't think the client is correct when he says that your nose is clean. Because the banks recently relied on your representation. Even if what you told them was technically true,
Okay.
that information was still used to commit a fraud.
Okay.
So I don't think your nose would be clean, even if what you represented in terms of what they had was true.
Okay. Okay. So, Ms. Harper, tell me, how are you viewing your client? Why are you less trusting of the client when you say that? 'Cause you said something that's really interesting. Even though this is technically true, it might be technically true. You just said, yes, they have the collateral. They do. But in order to make that work, you sort of have to look at way about the underlying facts about how they got this collateral in order to say that your representations are true. So how are you looking at the client?
I don't trust them this much anymore. This is to them it may not seem like a big deal, but to me as their attorney, this is a very big deal because that means they lied about underlying facts to me at the start,
Right.
or they told us what was going on.
Right, and so notice, we're going to see in chapter 5, this whole notion of undivided loyalty, that is eroded when you can no longer trust your client. So it seems like, and this is the point that's made on page 143, it seems that even though you have this language, unless prohibited by Rule 1.6, that discretion that the attorney has is limited and restricted by this duty that we have not to have our services used in criminal or fraudulent conduct. It becomes mandatory. It's restricted in these type of situations. So the book even says, this means that in a situation in which a lawyer's failure to reveal, as Harper's pointed out, failure to reveal this to the banks, constitutes assisting a crime or fraudulent act, Rule 4.1 now requires a lawyer to reveal that information. So not as permissive as you think. Not as permissive as you think. So what do you think happened in the real case?
Kept representing them.
I'm sorry?
He kept representing them.
Oh yeah. Now, kept representing them, and there are 2 law firms involved. These are major law firms. So the first law firm was Singer Hutner. I don't know if they're still around, but Singer Hutner. And they checked with outside experts. They checked with a professional responsibility professor at Fordham, as well as the then dean of Fordham Law School, who was being paid $500 an hour to give advice. And even after they learned that all of this was happening, $60 million of loans were fraudulent, the firm kept silent. And they justified their inaction by Rule 1.6. We can't tell this because to do so would violate Rule 1.6. We would be revealing client confidences. And we know we all must protect client confidences. They gave a benefit of the doubt to their clients' assurances that there was no ongoing fraud, and they continued to close loans on the theory that the fraud that they actually knew about was in the past. So this is just a common scenario where a client, they reason, comes to you for help, everything is already passed, and you're just rendering legal advice to help that client along. Your services aren't being used in anything because everything has already occurred, the argument goes. And so to be certain that this analysis was right, they go to the dean of Fordham Law School and a PR professor, and those experts advise the lawyers that they don't need to check with the leases' authenticity, these lease documents. They had no duty to withdraw the opinion letters to third parties that they had sent to the bank, because at the time they sent the letters, they were unaware of the fraud. And so, since the letters had been sent and received in the past, there was no ongoing fraud, and the legal services were not being used in furtherance of that crime or fraud. See how hard I'm working to make this making all of these arguments. They sound good. And you have people, so when the firm finally resigned, and the computer company was called OPM, Other People's Money, the client then hires Kay Scholler, still a major firm, and they come on board. But the new firm was not alerted to the old firm's ongoing fraud. And this is interesting. Think about when this new firm takes over, and we'll see this later on, when a new firm takes over on these matters, there are some confidences that will have to be shared because the firm will have to analyze conflicts, will have to analyze scope of representation, will have to analyze any number of things when taking on this new matter. But the new firm was not told about this ongoing fraud. So the old firm decides on the advice of its experts that it should not alert the new firm about this propensity to fraud. Quote, the decision to terminate was mutual, and there was mutual agreement that the circumstances of the termination would not be discussed. So that should raise a red flag to you there if you're taking over this matter. These two entities terminate their representative. You don't know why. You just accept it. So eventually, OPM's partners faced criminal charges. They were sentenced to 10 to 12 years respectively. The bank sued the new firm. The firm is obliged to pay a settlement of $10 million. There were others, defendants that paid in excess of $55 million. But as far as we know, no disciplinary action was initiated. The dean who gave this advice, I hate to tell these stories because it seems like there's no consequence. Everybody comes out okay. The dean who gave this advice later claimed that, well, I didn't have that much expertise in legal ethics. I was just giving a general opinion. He's appointed to the Southern District of New York and later federal court, and then later the Second Circuit. So nothing happens there. That's that. And then there was some turmoil about, well, should we change the disclosure rules to the current 1.6 that we have? And there was debate back and forth. But it would take 20 years, Enron and Sarbanes-Oxley, to really prompt us as lawyers to re-envision 1.6 to permit revelation of these confidences. So that is what prompted it. And it took 20 years after this type of case to do that. So not a good look for us. The rest of the chapter deals with limited disclosure. We sort of talked about that. I want to jump over to, before we do chapter 4, page 153, the investment project, problem 3.7. So notice the book is sort of giving you some little hints about conflicts. This is a conflicts case, and we're going to go through 1.7 concurrent conflicts, 1.8 specialized conflicts, which is, this is an example of 1.9, the former client representation. So we're gonna see, you have to look forward and backward when you represent, because you're representing the current matter, but something that you're doing may undo something that you previously did for a client. And that client has the right to expect that his or her or its work will be preserved and not undermined by the attorney who previously represented them. But this last problem in chapter 3 deals with how you handle confidences, and can those confidences be used in a way that is disadvantageous to the client. So, what about this? During the course of our representation, we are inspecting sites for new plants. So we have access to all of this good information, good confidential information. Our client company's research, we learned that developers are acquiring adjoining property, contiguous parcels of land. They're probably going to build a shopping mall. One parcel of land remains to be sold. Your client has decided not to buy land. So we have this confidential information. We have our client saying not interested. That seems to be okay. The value of this property, of course, is going to go up because the developers want to buy it. And then if you get in on the ground floor as an attorney, you might benefit from this. So notice this is the question. You would like to buy this parcel of land. Are you permitted to do so under Rule 1.8b? And then does your answer change if your client has not yet decided whether to purchase the land? So take a look at 1.8b. Can you buy this land? Yes, go ahead.
I think if the client has decided not to purchase the land, it's fine.
Okay.
If they still haven't decided, I think it would be inappropriate.
Okay.
But if they ultimately decide not to purchase the land and then you decide to, I think that's fine, just because the language says, shall not use information to the disadvantage of the client, and that wouldn't be to a disadvantage if they've already decided not to.
That's very good. That's good. That's the answer. So, but okay. That's the classroom answer, and that's good. Now, real life. Just your client says, no, I'm not interested. Is there anything you'd want to do, not to go overboard, but just to make sure, because notice you have all the power in this relationship. You have this great law school education, you have your expertise, you passed the bar, you've been studying and working on this for years, and the person says, no, I'm not interested. Now, this isn't a situation where you're in business with a client, but is there anything else you would want to do just because the client says, well, I'm not interested? Is there any follow-up?
Maybe, well, give a little bit of time between when they say they're not interested and then when you would actually like pursue an offer on the property.
Mm-hmm.
But more than that, because you kind of garnered the information about the value of the property from your relationship with the client, I would maybe create a document or something for the client to sign. And maybe if you had like a partner in your firm that could also look over it, something so that you weren't the only person saying, oh, here, client, sign this that I wrote, without anyone else looking at it, that sort of thing. But just kind of letting them, or I guess kind of acknowledging that they said that they weren't going to buy it, and then
That's good. So, this isn't a full-blown, informed consent scenario where you're in business with the client and we're concerned about overreaching on your power as an attorney. You're just making double sure that this person knows what is happening and occurring. You're going to buy this, and there's no disruption in the attorney-client relationship. The client doesn't think, oh, you did a slick one because you got this confidential information because of our relationship, and now you're using it. And it's fine if the client says they're not interested. Ms. Wagner, go ahead.
I was just going to maybe sum up
Yeah, tell me about that. So I guess the thing is this: how far should we go? Because we have a little leeway. I'm going to compare this with when you go into business with a client, just to introduce it, but we'll be doing that later. But how far should we go when we know that the client isn't interested? Is what we were just talking about enough, or you're suggesting a little more? Tell me.
I'm suggesting a little bit more. Say,
Okay.
I understand that you don't want to purchase this. Here's what I propose maybe, and here's maybe the scenario that could happen. Let them know that they have the choice, and that if they want to make the choice not to purchase it, you would like to, and just let them know how that might work out financially for them. Give them both sides of the story and say, if you still don't want to, I'd like to do it, and make sure that they're okay with that.
Okay, that's good. Okay, that's good. So you both recognize that we have to have some type of conversation. We want to preserve the loyalty, undivided loyalty that we owe to the client, because we would be using information, notice, relating to the representation. That's the confidence for our own good, and we don't want the client to feel like she has been disadvantaged. Information related to representation. And there's no disadvantage if the client doesn't want it. But what we're suggesting is, even if we have the green light, there should be some explanation to the client about how the information will be used. And so you can do this without having this conversation, but the better practical approach is indeed to have this conversation, because you're using information related to the representation. Wouldn't be to the disadvantage of the client, because the client says, I'm not interested, but explain the consequences of what that means. It's sort of getting sort of a preliminary type of informed consent. Go ahead, Mr. Johnson.
I was just going to ask, would it matter if, the fact that this land, surrounding land, has been sold to a development company, if that was like in the public record somewhere, so it's not like confidential, I guess.
So you're saying, so the status and zone of this land, you get this information publicly, so that would be outside of a confidence covered by a client, and you should be able to go ahead and do it, right?
Maybe.
Yeah, well, that's good. This shows how broad this is relating to the representation, because you came into that information by representing the client. So it's not just confidences that you learn directly from the client, it's anything relating to the representation itself. So I would say still have that conversation. Yes, Ms. Russell?
In practice, wouldn't that always be kind of construed against the attorney as having that information?
Yeah, tell me how.
Like, you'd be presumed to get any information that deals with your clients from them,
Yeah.
even if it is public or no.
Yeah. It relates to the representation. So that's why confidences are so broad. It's broader than just me talking to the client and getting this information. Oh, I'm interested in this land deal. It's at Lakeshore. Here's the zoning. That's fine, but you learn things about the filings, about the regulatory framework because of this representation. And if you use this information, it could disadvantage the client. So when a client isn't interested, that's fine, you move on, but have the preliminary discussion that we were talking about. If the client does have some interest, I think that changes the analysis. You have to give the client time to make that decision, can't pressure that client, and you can't go in and use this information to the client's disadvantage. You can't do that. And then there's another wrinkle to this rule as well. And we've sort of been talking about this around the edges. Conflict of interest, current client-specific rules. So I just want to just briefly look at 1.8a. So it says it is a bad idea to get into a business relationship with a client. I'm paraphrasing, but it says a lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, promissory security, or other pecuniary interest adverse to the client, unless. So A talks about a transaction, B talks about use of language. Use of confidential information. I'll just paraphrase. Shall not enter to business transaction with a client unless. So notice what this says. This says your duty as an attorney will be undermined on some level if you have a vested interest with your client. You have the power, the expertise, and it's going to be an unequal business relationship. And we don't want that. But 1.8 says, unless, okay, if you must do it, there are going to be 3 writings. I want you to be careful about this. So, generally, attorneys should not enter into a business relationship with a client. But if you must, it says there must be 3 writings. That shows you how important this arm's length transaction that you've been describing is. So, first thing we want, I just put fair and reasonable terms. In writing. That's the first writing. So if you enter into this business relationship, this transaction has to be fully explained to the client. What the lawyer's interest is, fair and reasonable terms, fully disclosed and transmitted in writing so that it can be reasonably understood by the client. So fair and reasonable terms in writing. Those fair and reasonable terms spell out the lawyer's interests, impact on the client, and it is explained in a way that it can be reasonably understood by the client. That's the first writing. Second writing. Desirability, and some of you hit on this, desirability of seeking independent counsel. In writing. So that's that outside party that could be neutral, detached, give the client an assessment about the viability of this business transaction. And you also have to allow the client time to digest this independent assessment of the transaction. And So we're fair and reasonable terms in writing that can be reasonably understood by the client. The desirability to seek independent counsel in writing. And then the client gives informed consent. Notice that runs throughout this rule. The client gives informed consent in writing. And so informed consent is a deep concept. It's not just, yeah, okay, I'm going to do this. Okay, that's fine. We want to tell the client about the consequences, impact of this type of transaction, what will occur, and clearly define and spell out the attorney's role. So the client gives informed consent in a writing signed by the client to the essential terms of the transaction, the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. So notice that it wants you to clearly identify any conflicts that could even be on the horizon. It's probably a problem if you're representing your client in a transaction in which you are the business partner, but if you choose to do that, it has to be spelled out what your role is, how it impacts the representation. So there may come a time if you did something really elaborate and you set up this corporation and you're representing the client in quotation marks, you might have to say, I represent the corporation, not you. And that could cause a conflict as well, because if it's a closely held corporation, the client will assume that, yeah, we're on the same page. You don't represent this entity, you represent me, don't you? And then the attorney would have to say, no, I represent the entity. So that could be a conflict as well. So that is chapter 3, the duty to protect confidences. One last thing, how would you approach this? This is about on page 154. So we made a big deal about preserving client confidences. And that last page of chapter 3 talks about a study that was done sort of tracking how often attorneys talk to their clients about our duty to possibly reveal confidences. And it says, it seems clear, however, that if a lawyer might need to reveal confidential information in a particular matter, a client should know that. But it seems like lawyers don't usually tell clients about that duty to reveal confidence. How would you approach that in practice? Because I guess the real concern is if you tell your client that there may come a time where I have to reveal your confidences, that's going to chill conversation. But on the other hand, the client should be aware of your obligations and how that might impact the scope of representation. So how would you handle that? I mean, you don't want to be heavy-handed and say, I'm going to have to tell everything about you, but that's just my duty, and my duty overrides anything that I'll do for you. That would be wrong. But how would you approach that? And the book really doesn't answer that. Notice it says the exceptions to the basic confidentiality rule are numerous, complex, and sometimes ambiguous. A lawyer should consider this question of whether to inform a client of potential discretion or duty to disclose confidential information before the first conversation with each client. So how do you approach that? Yeah, go ahead.
You just did like some basic general examples. You know, if you're using my services to commit a fraud such as.
Okay. And the highly unlikely event that you would be using my services to commit fraud, I would have the discretion to reveal. Yeah. Maybe that's good. So maybe just go through 1.6 B1. talk about those exceptions and what they mean in terms of the representation. That might be good. Now, are you concerned, and this is probably why not a lot of lawyers do it, are you concerned with chilling conversation if you have that type of discussion with your client?
That is a concern, but if you give them examples, they know what they can't tell you, and it just kind of avoids that. I thought everything I said was private.
Right. Good.
Maybe also just really emphasizing the broad range of things you cannot disclose, and instead of focusing on these like narrow examples where you may have to emphasize how much the privilege actually protects as well, might help.
So a lot of, you would sort of give the things that you cannot disclose, and then how would the client know about the duty to disclose?
I mean, just by lodging it in a broader conversation about attorney-client privilege.
Okay,
Hey,
yeah.
let's talk about our privilege here. And here's all the great things it does. Here's just a few narrow examples.
Okay.
Such as committing fraud.
Yeah, that.
In the unlikely event that.
That's good, and so that sort of lines up, and that's a good sort of transition into the next chapter. It sort of lines up with this broad duty to protect confidences and the attorney-client privilege, because on either one of those scenarios, information relating to the representation or information that we want to protect from being compelled in discovery, in either one of those scenarios, we cannot help the client commit a crime or fraudulent act. So there are some instances where the duty to reveal is stronger than this undivided loyalty, and that could be a way to couch it. Good. So, Chapter 4, the attorney-client privilege in a work product doctrine. So, you've gotten most of this in Pro, but let me just sort of make a couple of points. So, what do you think, and this is a good way to sort of frame this chapter, since we're coming out of confidences. What do you think the difference is between the confidentiality that we've been talking about and this attorney-client privilege? But some people say, well, the attorney-client privilege is a kind of a small subset of what we have been previously talking about when we talk about confidences. So we have confidentiality, and we have privilege. Well, one thing we've been saying, confidentiality is broad, privilege is narrow. So what about that? Based upon what we have talked about in the confidentiality chapter, how would you compare that with privilege? How would you compare that with privilege? Well, a number of things come to mind. You know that confidentiality is broad. Confidentiality that we've been looking at comes from the ethics rules. privilege, evidence, and so we also said that when we talk about confidentiality, we're saying this. We're requiring lawyers to protect confidential information whether or not someone is trying to compel the disclosure of the information. So, that's broader because we've been talking about relating to the representation. And so our duty not to reveal these confidences comes from the ethical rules. Not because we're trying to protect the information from disclosure from some type of process or discovery mechanism. And so that's what makes it broad. We're talking about all information related to the representation that a lawyer obtains. And so if you violate this, you're subject to discipline. Now, how would you compare privilege? You said it's narrower, but out of this chapter, what makes this different than what we've been talking about in terms of confidentiality? Yes, go ahead.
Well, privilege is more so related to, like you put on board like evidence, so it doesn't have anything to do with facts that your client tells you. It's all based on anything that you give legal advice about.
Okay, good. That's good. So that's good. So you sort of identified information that comes out of the relationship itself, and then there's some type of mechanism, and we're trying to compel that disclosure. And we're saying, no, this is coming in terms of representation, and we're saying that either the lawyer nor client may be compelled to testify in court or for the proceeding about protected communication. And this is we're gonna see in two scenarios. One is from the representation itself, and that's broken down in the book, and then the work generated by that representation. And so it was pointed out that you have communication between lawyer and client in which the client is seeking legal advice or legal services. So on some level, this is a subset of confidential information. But it is dependent upon the work that an attorney does. And so here we're talking about discovery practice as the remedial framework to deal with the assertion of a privilege. So this breaks down, if we're talking about the elements of the attorney-client privilege, you have several things. You have communication, between lawyer and client. You have privileged persons. Communication and confidence. And I'll just put for the purpose of seeking legal assistance. So the book goes through each of these components and discusses the definition of them. And so you see, starting on page 158, what the book emphasizes is that you have to be very careful in this context. So you have the rules of confidences that we talked about, and we have privileges as well. But we want that privilege to attach, and so we want to be very careful about how we conduct our business. So if you have an interpreter in the room that works for you, you interview the client, and then sometime later opposing counsel says you've waived the privilege because you had an interpreter in the room. How would you argue? How would you deal with that argument by opposing counsel? Opposing counsel said, I deserve to hear everything that you said to this client because there was a third person there, the interpreter, therefore you waived the privilege. I'm going to go to the court and get them to compel you to give me this information. Go ahead.
The interpreter was there because they were needed to facilitate the communication between the lawyer and the client.
Good.
So in that context, they're privileged because they were the go-between in order to facilitate the communication.
Okay, good. What if there's a guy that just hangs around the office and he's thinking about being a lawyer, so he just wants to observe and take notes on different things. He wants to be an apprentice one day and learn how to be a lawyer, and then maybe go to law school. So he comes to some of your interviews and takes notes. Opposing counsel finds out about that, does the same type of motion to compel discovery of these statements because you waived the attorney-client privilege. What about that? Yeah.
I did that over the summer at my job, and they made me sign like a thing that basically bound me to like the same rules as the lawyers.
That's good. And why do you think they did that?
I guess because otherwise maybe it would be, I mean, we don't really do anything like litigation, but I mean, it could violate the privilege.
Oh, yeah, it doesn't matter, it could be a transaction or whatever, a deposition, that's good. And so they want to make sure that you're just not an extra person around and therefore you waive the privilege. And so that's why they had you sign it. The lawyer should always clarify the role of third parties to avoid waiver. That's on page 159. So what about this notion? Underlying facts are not privileged. So this might be a distinction you have to make in discovery practice. So opposing counsel is trying to get all of your information, and you say, no, this is attorney-client privilege. This is a communication between the lawyer and client. All the privileged persons are there, no waiver. Communication in confidence. Not so much relating to the representation, but within the context of this representation, not as broad as confidence is, for the purpose of seeking legal assistance. But then opposing counsel comes back and says, well, all of that's fine and good, but I'm not really talking about privilege. I'm talking about the underlying facts. How do you make a distinction between those two? And so what I'm getting at is there could be a scenario where you get at this information another way apart from attorney-client privilege. But what is this distinction between underlying facts and protected information under the attorney-client privilege? Like that example on 161, how do you explain that? Underlying facts are not privileged. So how do you segment what the client tells you that is protected and what has to be revealed? So what's the difference between the client telling you, yeah, I really was driving carelessly. I probably took too many prescription pills and just got the new prescription, didn't read it carefully, and I probably did some of that. So that's one. And then what if opposing counsel says, I want you to tell us everything. How many pills did you take? Could you say, instruct the client not to, this is at a deposition, instruct the client not to answer. You don't have to tell them how many pills. That's attorney-client privilege. So what's the difference? Yes, go ahead.
Just a fact like what time did you take it, how many did you take, they have to answer, but I don't think that they're required to speculate that it was too much or that it might have caused them to be tired.
Okay, that's good. So what's the difference between those two?
One is just a fact and one is more of a theory or an opinion or...
Theory or an opinion that may have been gone over by the attorney-client in confidence, seeking legal advice. So you can't be compelled to testify about what the client told the lawyer in seeking those legal services. But the underlying facts of this particular transaction or the accident are not privileged. I mean, everyone is able to get that type of information. Another thing is that the privilege is waived if the client reveals the privileged information to a non-privileged person. So that could be a very dangerous now, particularly with social media. So I went to my lawyer's office today, and he told me how we're going to win this case. We're going to win $100,000. Here's how, and then have your friends vote on that. This is the best strategy, like or not like. And so you would probably waive that because there's so many non-privileged. You've expanded the group in this conversation, and whenever that occurs, there is danger of waiver. No privilege attaches if the client consults a lawyer for assistance in committing a crime or fraud. So that just builds upon what we were talking about with Lisa's pieces in Rule 1.6b2 and b3. Your services cannot be used in the furtherance of a crime or fraud. An attorney-client privilege carries this forward with the crime fraud exception on page 165. So there is a clear distinction, remember, between past crimes and that you're advising the client on and advising and assisting in the commission of the crime. You're advising and assisting in the commission of a crime, no privilege. Another thing on page 166. Now notice this. This is interesting. There is a case, you don't remember, this is a long time ago, but anyway. During the Clinton administration, Vince Foster, who was high-level Justice Department and advisor to the Clintons, was found dead in Rock Creek Park in D.C., committed suicide, just shortly after getting to D.C. And there was an investigation, and it unravels in the Ken Starr investigation. But anyway, there was litigation. Ken Starr wanted to get notes that Vince Foster had taken and talked to his lawyers about. And there's a case from 1998, Swerdler in Berlin versus United States, that says the privilege survives the death of the client. So notice this. This even says on 166, the attorney-client privilege remains in force even if revelation would prevent the wrongful incarceration or execution of an innocent person, and it remains in effect after the client dies. How much sense does that make to you, that it lasts that long? And you have a choice between doing justice and doing the right thing, or preserving the reputational interest of someone who is no longer here. So if we say that the right of privilege belongs to the client and we can't waive it unless we get some express authority, and now the client is dead, why can't the lawyer exercise discretion and reveal this information? And that's the question that we have on page 167. How did you approach that? Secret confession on page 167. So notice there's this notion of justice, doing what's right, revealing, and then what the rule says. And you can even look at, there's another rule that sort of goes along with this. If you look at even comment 20, comment 20 to rule 1.6 says the same thing that it says in our book, that this duty not to reveal or preserve confidences is indefinite. Says something like this. Now, so this is sort of underscoring something that we're going to do in some subsequent chapters when we talk about former client. So keep in mind, just because you stop representing a client does not mean that your duties cease. And we're going to see this over and over again when we talk about former clients, when we do the conflict rules. Notice this, the duty of confidentiality continues after the lawyer-client relationship has terminated. So, you know, the difficult thing about this rule is, whether we're talking about attorney-client privilege or confidence, is it just says it goes on, and it doesn't give us any measuring stick about when does it end. And it doesn't seem like it ever ends. So look on page 167. We represent a client, James Chester, who is involved in a murder. And the client Chester, you see on page 168, says that he did it alone. He killed the victims, and someone who is incarcerated, Parnett, is not involved. See on top of page 168. He asked us what he should do. We're his attorneys, and we advise him to reveal. If we advise him to reveal that he committed the murder, the prosecutor may refuse the plea agreement and seek the death penalty. If you alone did it, we're going to hold you responsible. And so you have a number of scenarios there on page 168. May we reveal to the prosecutor before Parnett is sentenced to life in prison that Chester has confessed, our client has confessed to the killing and exonerated Parnett. Can we reveal the client's confession to us? What do you think? So, a number of ways to look at this. Justice means something, and even if it means throwing our client overboard, there's a higher and nobler purpose, so we reveal whether our client wants to or not. Can we do that? Put justice for Parnett ahead of everything else. In fact, 1.6b1 allows us to reveal because jail is so hazardous that the threat is imminent, and that gives us discretionary power to reveal, and we should reveal. And so even though the rule requires us to protect the confidences of the client, there is some harm here that we could identify that would allow us to exercise our discretion under 1.6. What about that? Would you reveal? So if Parnett goes to prison, he could get stabbed, violence, any number of things. So should we reveal to the prosecutor? Yes, Ms. Hart.
Morally, I would say yes, but in terms of legal ethics, we're still bound.
Okay.
Which is a horrid situation.
Indeed.
Because that puts you in a completely awkward position in terms
Yeah.
of your duty to the client, but also your duties and officer of the court.
That's good. That's good. And so this is all about assessing risk. That's good. That's good. Now let me ask this. So, what about my 1.6b1 argument? Can I really push that and say reveal?
That's really stretching it. Although I do agree, yeah, prison is of course hazardous, but it's still a stretch that I'm not sure like most people would buy.
That's true. And it's too speculative, I guess. And even though the rule isn't great in giving us an example, it probably needs something more imminent than this can occur in a particular location. So go ahead.
No, I was gonna say he can get stabbed anywhere.
Yeah, okay. Yeah, that's right. Anyway, yeah. So, this class is heartless. They don't care. That's good, but that's right. So and what you're underscoring is where's the eminence? It can happen anywhere. And if you're gonna exercise this discretion, you probably need a stronger base. Yeah.
I thought if you had information that would exonerate someone, you had to disclose it.
Say that again.
Like if you have information that would exonerate someone, don't you have to disclose it?
Why?
Why?
Yeah.
Because you're
Oh, it's the right.
falsely accused.
Yeah, it's the right thing to do, but what about this? Our duty to preserve confidences. You're not gonna like this. And then on page 166, notice this. Traditionally, the attorney-client privilege remains in force even if revelation would prevent wrongful incarceration or execution of an innocent person. And it remains in effect even after the client dies. That's bad, isn't it? So now in real life, what would Harper just said the rule, and you're reacting to that rule by saying, well, that's not right. So what would you do in real life?
Are you asking me?
Oh, yes, yes.
Honestly,
Ms. Durbin,
I'd
yeah.
probably like put in an anonymous tip because like I'm not gonna let somebody die. Like,
Yeah, it's a risk, and so this is to show you that it's not a perfect world, and you might have to make something. So we know what the rule, we shouldn't disclose, that's what the rule says. But then you're thinking about justice, you know someone is innocent. And then, you know, question 2 sort of makes that point. Does your analysis change if someone is sentenced to death row? Same thing. It's not really absolute. So even if we have this rule under 1.6b1 that would excuse us from the duty of confidentiality, there's no life-saving exception to the rule that would allow us to fail to honor the absolute attorney-client privilege, and that's bad. And we can't really exercise this greater discretion to prevent death. Go ahead.
That makes no logical sense because
Yeah.
that severely puts attorneys at odds with
Sure.
what they're supposed to do.
Indeed. So what should we do then?
Honestly, if it were me, I would take the risk and
Mm-hmm.
I would do it.
Mm-hmm.
Would it put, like, but that's just for me personally because morally, that's not something that I could just stand by and let happen, especially if it were a death penalty case and I knew they were about to execute this.
Yeah. So notice, this is the tension you're identifying in this discussion. A lawyer's decision not to disclose as permitted does not violate this rule. So this might be burning in your conscience. I know this, I can reveal, but it would be a risk because it's really prohibited by the rule. Comment 20, as I said, the duty of confidentiality continues after the lawyer-client relationship has terminated. And notice what happens. Our client commits suicide, leaving no family behind. Can we now reveal? So he's dead, and the question is, does it make sense to protect this reputational interest? Cases say yes, it does make sense. So the client, even in death, maintains an interest in protecting reputation. So may you reveal? You're still concerned with justice. Now notice, to resolve this, notice number 4 on page 168. This is exactly what happened. So Ms. Harper, Ms. Durbin say, this is horrible. We need to deal with this. And I know what the rule requires, no revelation, but I'm going to take the risk. Because discretion has to mean something if we're trying to save someone's life. So assume we decide to reveal Chester's confession to Parnett's lawyer. Now notice, the one consequence is this. Now, if you do that, you have to be aware that now you're going to be a witness probably, or at least subpoenaed. So that's one thing to think about. And so he subpoenas you to testify at the hearing on the motion for the new trial. There's no one else but you really to talk about this. During the hearing, you're about to tell the judge your client Chester's confession. Now, this is what happened in the real case. The judge said, you better stop. I'm going to have to report you because we know, and he sort of gets confidences and attorney-client privilege mixed up. But anyway, for our purposes, you have to preserve the client's confidences. I'll be compelled to report you to the state bar for violating your former client's attorney-client privilege, which outlasts his death. So the reason I said it's more confidence is because attorney-client privileges, as we put up on the board, it attaches to some type of proceeding, and we're trying to compel, and now we have the client who's dead. But anyway, we still have to protect this information. In the real case on which this is based, this is what the judge warned. So, what do you think happened? You can comply with the judge's order and stop. You can testify anyway. And until he orders you to stop, will testify no matter what. And this was an actual attorney, a public defender. So all of you are asking, divided loyalties, how can you let an innocent man stay in jail? The attorney revealed the client's confession after the client died. The judge did report it to the state bar. And what do you think happened? Think the lawyer got in any trouble or what? Well, all of you were like, reveal, this is wrong. What do you think? You think anything happened when you took this risk? No. Good. So this was in Massachusetts. The bar complaint was eventually dismissed. I mean, but you go through, you get investigated, this and that. But ultimately, the bar complaint was dismissed. Now, I'm sorry, that was in North Carolina. The reason I said Massachusetts is this. To sort of address the concerns that you all said, well, someone's about to die, or we know that this person is innocent. One rule, and this sort of changes 1.6 to allow you to disclose. So it says, and Ms. Harper, you mentioned officer of the court and all of that. There's a Massachusetts rule that says, makes it permissive. It says, a lawyer may reveal, and to the extent required by 3.3, officer of the court. 4.1b, you cannot assist in fraudulent or criminal activity. Or 8.3, reporting misconduct, may reveal confidential information to prevent the wrongful execution or incarceration of another. So notice what that does. That's a nice permissive rule. It is 1.6b. This is just in another state. This is how they resolve the issue. So they give you the authority to reveal. A lawyer may reveal and notice this, and to the extent required by 3.3, that's candor to the court. 4.1b, that's truthfulness in transactions with others. Or 8.3, that's reporting misconduct. May reveal confidential information to prevent wrongful execution or incarceration of another. So notice what that does, the last point. Notice what that does. It gives you more discretionary power under 1.6, sort of removes this qualitative assessment of what imminence is, and says if someone is wrongfully on their way to execution or incarceration, the lawyer has the power to reveal. And so it plugs it into some mandatory obligations that the attorney has. Candor towards the tribunal, can't commit crime or fraud by having your services used, being truthful to third parties, and reporting misconduct. So that's just a way that Massachusetts has thought about dealing with this. When we come back, we'll finish up this chapter. We have one more problem, worldwide married, and then we will start chapter 5, lawyer-client relationship. Have a good afternoon.
Random every day.